How can a landlord do a private prosecution for fraud in Ontario? In Ontario, a landlord can initiate a private prosecution for fraud if they believe that a tenant has committed a criminal offense, such as providing fraudulent documents or false information to obtain a rental property. Private prosecution allows individuals to bring criminal charges against another party without the direct involvement of the police or Crown prosecutors. Here is how a landlord can pursue this process. Gather evidence. Collect all relevant documents that support the claim of fraud. This can include the rental application, lease agreement, communications with the tenant, copies of fraudulent documents, and any other evidence that shows the tenant's intent to deceive. Identify any witnesses who can provide testimony regarding the fraudulent activity. This may include property managers, neighbors, or other tenants. Consult with a lawyer. It is advisable to consult with a lawyer who has experience in criminal law to understand the viability of the case and to ensure that all legal procedures are properly followed. The lawyer can assist in drafting the information, which is the formal written statement of the charges against the accused. Swear the information. The landlord must go to the Justice of the Peace at the courthouse and swear the information under oath. The Justice of the Peace will review the information and decide if there is enough evidence to issue a summons or a warrant for the accused to appear in court. Complete the Form 2. This form is used to lay the charge and must include specific details about the alleged offense, such as the date, location, and the nature of the fraudulent act. Court hearings. If the Justice of the Peace finds the information sufficient, the tenant will be summoned to appear in court. The first court appearance is typically a procedural hearing where the charges are read and the case is scheduled for further proceedings. At this stage, the Crown Attorney may review the case. If they decide to take over the prosecution, they will proceed with the case on behalf of the state. If not, the landlord, or their lawyer, will continue to act as the prosecutor. Prosecution process. There may be pre-trial motions and hearings to address any legal issues before the trial begins. During the trial, the landlord, or their lawyer, must present evidence and witnesses to prove beyond a reasonable doubt that the tenant committed fraud. The tenant, who is the defendant, will have the opportunity to present a defense. If the tenant is found guilty, the court will determine the appropriate sentence, which can range from fines to imprisonment, depending on the severity of the fraud. There are many challenges to consider before undertaking this time-consuming and potentially costly endeavor. Private prosecutions can be complex and costly, requiring significant time, resources, and legal expertise. The landlord must prove the fraud beyond a reasonable doubt, which is a high standard of proof. The Crown Attorney can intervene at any stage and decide to take over or discontinue the prosecution. Private prosecution for fraud is the legal avenue available to landlords in Ontario, but it is a challenging and resource-intensive process. It is essential to gather substantial evidence, seek legal advice, and be prepared for the complexities of a criminal justice system. Considering the potential challenges, landlords may also want to explore other legal remedies available through civil courts and the Landlord Tenant Board.